So I want to bring in our legal panel to help unpack, again, some of these big decisions. A few of my favorite people all together on one screen here. Great to see everyone. We have Thane Rosenbaum, who's a distinguished professor at Touro University. Amir Benno, it's been a long time, constitutional law attorney and Newsmax legal analyst, and also Katie Cherkosky, who's a constitutional law attorney and former federal prosecutor. She is also a California girl like me, and so we probably woke up thinking that we were going to have very similar minds and wearing a similar wardrobe. So just to let our viewers know, that was not coordinated. Amir, I want to kick it off with you. The only decision that we got this week, not one of the major four that we've been watching, but a significant one nonetheless, was determined to be a major win for the Biden administration. The justice has ruled 8-1 in favor of the administration's appeal of the judge's ruling that it halted DHS guidelines narrowing the scope of those who can be targeted by immigration agents for arrest and deportation. Break down this ruling for us and why it is effectively being considered a victory for President Biden.
Well, the border states wanted to be able to, and by the way, it's nice to see you as well and my distinguished colleagues on the panel. Look, the border states wanted to be able to make the arrests of these individuals, and they didn't. Essentially, what this allows the administration to do, the Biden administration, is to prioritize who gets deported. So not everybody who's here, they can set their priorities. They can't deport everybody. They can't put everybody into removal proceedings, but they can select which ones that they want to. So some will essentially fall through the cracks. Other ones will get sent away. And that's clearly not what I think the border states wanted. They wanted to be able to have more control over who they're ejecting. And so that's why it's viewed as a win. But I think the big items that we need to be watching in this coming week, Kilmeny, are the affirmative action case. Obviously, there's a big First Amendment case that's coming out. There's another one that has to do with the independent state legislature doctrine that has to do with the power that the state courts have to control redistricting. And those are major ones that we're expecting to come this week. The affirmative action one has been a long time. It's been about 2 years since they granted cert on that. And that is going to be a big shakeup, I anticipate, much along the lines of the Dobbs decision was last year.
And of course, what Amir is referring to is Students for Fair Admissions has brought the case against not only Harvard, but the University of North Carolina, representing both the public and the private sector of education with regard to their race-based admissions policy. Thane, talk to me a little bit about what the reaction would be if indeed the Supreme Court decides to roll back something that's been in place for decades.
So, Kilmeny, what this court is essentially saying is we have nothing against diversity per se. We just don't think that you can achieve diversity through racial preferences and racial balancing. Race needs to be neutral. So if you're a really good hockey player, we can set aside a spot for you, or if you're a violinist, for you, or even if your parents went to this school, for you. But we're not going to set aside on the basis of skin color because we're supposed to be colorblind. And as Chief Justice Roberts once said, the only way to stop discriminating on the basis of race is to stop discriminating on the basis of race, saying the mere fact that you're setting aside slots for people of color is essentially discriminating against, in this case, Chinese Americans that have very high test scores and are discovering that they actually represent a much smaller percentage of what they otherwise would achieve in admissions, and they're blaming racial preferences as part of that reason.
I want to pivot for a moment to two challenges that have been brought against President Biden's student debt loan relief plan, Biden versus Nebraska and the Department of Education versus Brown. The first one was filed by 6 Republican attorneys general. They say that the Biden administration's use of the HEROES Act, which is a post 9/11 law allowing the Secretary of Education to respond to a national emergency by waiving or modifying a student loan plan to alleviate the financial burdens. That's one of the cases. And then, of course, the other case is 2 individuals who say they can't take full advantage of the program. Katie, how are you reading those?
Well, those cases are very interesting because when we're looking at Biden's student debt loan relief, we're really looking at whether the president overstepped his authority to use a law that exists and expand it to something that it was never really intended for, or at least that's the argument. So the court could strike it down on that ground. But on the other hand, there's a question about whether the states that brought this suit actually have standing to bring the suit. So it's more of a technical determination. And ultimately, Congress itself could decide to pass something like the Loan Forgiveness Act. But the question here is whether the president had the authority to do so.
That's going to be an interesting question. All right, we'll see if we get those decisions coming up this week. Thane Rosenbaum, Amir Benno, Katie Chukowski, thank you all for being here.